Hi, my name is Angelica Radomski. I am a senior graduating this December. I am a political science major with a global studies minor, and I also completed my paralegal certificate here at Marist. Ever since I was young, I've always been interested in the legal field. So for this project, I want to focus on the injustices in the legal system, specifically bail. Since the start of the bail system, certain groups of people prevailed while other groups of people suffered the consequences of an unjust system. The idea that someone can pay or have a loved one pay a certain amount of money in order to secure the release and create an incentive to appear in court has been a long time practice. Unfortunately, for the less fortunate individuals in the United States, almost all the options to be let out on bail include money. This forces many people to succumb to pre-trial detention, facing the negative consequences associated with it. There have been many attempts to reform the bail system. In my project, I researched the risk assessment tool, electronic monitoring, and the complete removal of bail for misdemeanor crimes and felonies. However, I argue that even the most successful alternatives for bail reform pose serious problems with inequality and inefficiency. Due to the fact that monetary bail is the most common use of bail, many people are forced to succumb to pretrial detention simply because of their inability to afford paying bail. On any given day, 60% of the US jail population is composed of people who are not convicted but are being held in detention as they await the resolution of their charges. People who are detained before their court hearings are more likely to plead guilty or to take a plea to a crime that they didn't commit. Also, the mental health effects that pretrial detention can have on someone are astronomical. People with mental health issues before entering pretrial detention were seen to have exasperated symptoms while in jail. This is especially problematic due to the limited number of mental health treatments available in local jails. Not only does the atmosphere of jail greatly affect the defendant, but the defendant is taken away from all life responsibilities. Defendants can lose their jobs and struggle to make ends meet for them and their families, even though they have yet to be convicted of any crime. Defendants may have difficulty finding future jobs with an arrest on their record. The results of the study in my project showed that defendants who are released on bail receive shorter sentences than people who are not released on bail. When thinking of reasons why this is so, it can be concluded that when people are in jail before their trial, they have less of an opportunity to be part of their defense. For example, people who are out on bail can spend more time looking for defense attorneys, as well as participating in more discussions with the attorney. However, when people are in jail before their trial, they do not have the option to look for the best attorney or participate in many pretrial discussions with their attorneys. This is why change and reform is needed for bail. For my project, I studied 3 alternatives for bail reform. The first is the risk assessment tool, algorithmic tools based on predictive analytics. A pretrial services agency discovers certain information about a defendant and compares that information with past defendants. They ask themselves 2 questions. What is the risk that someone accused of a crime will not appear in court? And second, what is the risk that this person will endanger public safety? The algorithm includes specific factors such as criminal history, job status, level of education, family income, presence of a permanent address, and many more. These factors are then entered into an algorithm. The algorithm takes into account certain weights of each factor, and then a final score is given. However, there's problems with this. The procedure of giving a judge a numerical number can be very misleading. Judges are only given a number 1 through 5 from the pretrial services agency. The judges are not given specific information about how the number was formulated. The judges can also misinterpret the numbers. For example, a 1 on the scale does not correspond to a 20% risk. On the same note, a 5 on the scale does not mean an 80% risk on the scale. Another problem with the risk assessment tool is that it can be biased. Many people think that just because it's a computer-generated algorithm that no human bias is present. However, this is held to be untrue because the computer and its program was created by humans, inherently making it biased. The second reform to bail, which I have studied, is electronic monitoring. Electronic monitoring is used as a substitute for pretrial detention. The control unit and receiver are retained by the authorities. The trigger is adapted to receive an activation signal from the control unit and responsively activates the transmitter unit. An antenna wire is embedded in the band and transmits the transmitter signal as a detection signal throughout the vicinity of the individual. Strapping of the band to the individual, closing of a band switch, couples the antenna wire to the transmitter unit. Periodic and random checks are made by the operation of the receiver in the vicinity of the individual's home or apartment. The defendant is forced to wear the bracelet 24 hours a day through the oversight of a supervisor. The defendant must respond to the supervisor as frequently as requested, as well as ask for permission when leaving the house, even in times of urgency. There are many advantages to this system. The first is that the system is substantially tamper-proof. Should the band be removed, the transmission terminates. Ultimately, there is no way a defendant can get away with meddling with the system without immediately contacting the authorities. The band is small, waterproof, and can be reused once properly cleaned. The savings outweigh the cost of implementing the program, with the average savings per person being around $4,000. Electronic monitoring is much less expensive than incarceration. Also, citizens' taxes are paying for incarceration, while in this case, the defendants pay for their own electronic monitoring. However, the negative effects outweigh the advantages. The problem posed with electronic monitoring is that it is used very often, even when it is not necessary. Since it is very easy to use, judges seem to implement it as the only alternative to pretrial detention. However, if people are deemed safe to be in the community, there is no need to infringe on their rights by forcing them to wear an ankle bracelet. One of the main issues that people complained about was the monetary costs associated with electronic monitoring. Defendants are responsible to pay for all the costs associated with the system. In a study I researched, most of the participants stated that they had to pay over $70 a week. This added up to around $3,640 a year for the electronic monitoring system. When asked about the bracelet itself, many people have reported that it is very uncomfortable. Both men and women have reported issues with wearing and not wearing certain clothes to adapt to the bracelet. The strap on the bracelet was said to be very itchy and troublesome. In another survey I studied and researched, a respondent mentioned that the constant phone calls from her supervisor in the middle of the night would wake up her entire family. When the electronic ankle monitor would go off and make loud noises, the entire family would be disturbed in whatever task they were trying to complete. The third bail reform which I have studied is the complete removal of bail for certain nonviolent felonies and misdemeanors. On January 1st, 2020, New York State underwent significant changes to its bail system. The most substantial change included the elimination of cash bail for misdemeanors, nonviolent felonies, and certain violent felony robbery and burglary charges in the second degree. Instead of determining whether or not someone is a risk to society and whether or not the defendant will appear in court, everyone who is charged with these crimes are automatically spared pretrial detention. One of the main purposes of this bail reform was to alleviate overcrowding in jails. Governor Cuomo achieved his goals of alleviating prisons. By April 2020, only 4 months after the law was passed, New York City's pretrial jail population decreased by 40%, with even more impact in other parts of the state. Overcrowding in jail leads to many negative consequences for both the facilities as well as the defendants who are detained inside the jails. Overcrowding can cause more violence and conflicts between inmates themselves and between inmates and staff. When a jail takes more people than its capacity, there are less resources and services to share among the detainees, because there is a decrease in the availability of funds per inmate. Although the law succeeded in achieving its goal in lowering pretrial detention, many law enforcement officials were angered by the new bail reform law. In January, the same month the legislation came into practice, the NYPD released statistics revealing an increase in crime. In April 2020, 4 months after the initial bail reform law was passed, Governor Cuomo in New York decided to amend the law. The state made more crimes and situations eligible for cash bail and pretrial detention, in hopes of lowering the crime rate. According to the Legal Aid Society, cash and insurance bond bail are the most common types of bail used. The idea that a person's freedom depends solely on whether or not they can afford to pay bail is very problematic. According to the Justice Policy Institute, the average bail amount in the United States is around $55,000. This means that 80% of people would have to pay about a full year of income in order to pay their bail. When looking at which ethnic groups monetary bail most disproportionately affects, it is clear that Blacks and Hispanics are facing great injustice. Almost 60% of the people incarcerated in the United States are Black or Latino. Members of the Black and Latino communities are disproportionately jailed when compared to the white population. According to the Brooklyn Law Review, Blacks are jailed at nearly 12 times the rate of whites and Latinos more than 5 times the rates of whites. In a study I researched, it investigated whether the dollar amount of bail set by judges are different for people of different races. The researcher proposed that after the combined effects of legal and extra-legal factors were taken into account, Hispanic defendants receive higher bail amounts than do their white and African American counterparts. In order to test this hypothesis, a study was set up. The study was conducted using cases from the District Court of Lancaster County in Nebraska, including information on all white, African American, and Hispanic persons accused of felonies that were still eligible for bail. The results were appalling. The average bail for Hispanics was much greater than the average bail for whites and African Americans. The author wrote, the results of a sheaf test showed that $24,404.55 was the average bail amount given to the Hispanic defendants, and it was $15,033 greater than the average for whites and $14,918 greater than the average for African Americans. This supports the argument that judges are relying on race as well as other factors when determining bail amounts, causing discrimination and injustice for certain minorities. Although there have been many attempts to reform the bail system, each alternative nevertheless consists of notable problems. The risk assessment tool, although consists of certain benefits, undeniably continues to discriminate against poor minorities, as it involves inherent bias in its framework, as well as misleading data, which leads to misinterpretations for judges and accordingly impacting their decisions. Electronic monitoring could be cost-effective for taxpayers, as well as efficient in alleviating crowding in jails, concedes to its own complications. The form of bail shifts the financial burden from taxpayers to defendants, causing increased hardships. Along with financial burdens, electronic monitoring restricts the defendant, who is presumed innocent until proven guilty, of certain liberties such as independence, communal ties, and physical freedom. Lastly, the automatic pretrial release of misdemeanors and certain nonviolent felonies, although has dramatically decreased jail populations, has caused an increase in crime rates in certain communities, such as New York City. With this being said, there are still multiple problems that need to be addressed and ultimately eliminated. The inherent bias and discrimination in the criminal justice system needs to be addressed before true bail reform can happen. If judges are relying on past criminal records, even in cases where a defendant was unjustly affected, then we need to dig deeper to the root of the problem: the racial profiling and discrimination in our criminal justice system. Although there have been many attempts at bail reform, the problems associated with it are ever present. Simply fixing some parts of the problem is not enough. More time, research, energy, and attention needs to be applied to criminal justice reform before successful bail reform can be made.